It's my special privilege to introduce our next two speakers, looking at freedom of religion or conscience, ? Our first speaker is Professor Roger Trigg. Roger is a towering figure in philosophy of religion, science and religion, public policy, and in particular questions of religious freedom and freedom of conscience, discrimination and equality in culture and law and philosophy. He's the author of Equality, Freedom of Religion with OUP in 2012, which is a fantastically incisive and penetrating overview of the landscape on freedom of conscience and freedom of religion issues, and it fell perfectly between the Equality Act 2010 and the Marriage Same-Sex Couples Act 2013, two acts, of course, that opened up all sorts of challenges and complexities in this area. We're very fortunate to have Roger with us. Secondly, Professor Francis Beckwith, Frank, who is the Professor of Philosophy and Church-State Relations at Baylor University and author in 2015 of Taking Rights Seriously, Law, Politics and the Reasonableness of Faith. It's an extremely incisive account of the rapidly developing issues and questions and problems in a US context. And so we're very fortunate indeed to have this transatlantic duo to be leading us by the hand from the historical hinterlands up into the philosophical highlands of the contemporary landscape on questions of freedom of religion and freedom of conscience. Professor Trigg, over to you.
Well, thank you very much for that introduction, and thank you very much for the invitation to be here. I'm very pleased to be here. A couple of weeks ago, I was at a conference on Capitol Hill in Washington, D.C., and one of the speakers made the point that if there's any one religion in a country, you get coercion. If there are two, they're at each other's throats, and if there are three, everybody minds their own business. I'm not sure that that's altogether true, because we now live in a pluralist society, and I still feel that there are fights going on, and one particular fight is the fight of the secularist, and I don't mean the kind of soft secularist talking about neutrality, if that's possible, but the hard secularist who is against religion. There is that kind of fight going on, and there's a wish on the part of many for a majority to dictate what happens for the minority. And freedom of religion, of course, is all about protecting people's rights, especially if you're in a minority. I suppose it is a sad fact, just looking back at history, just linking up with the last session, that the people who are most concerned about religious rights are usually the people in the minority who are at the receiving end of coercion and persecution. Hence, the Baptists at the beginning of the 17th century were the first to talk about human rights. I think it behoves us all, even if we're sitting fairly comfortably, to remember that we ought to defend human rights even when we're in the majority, if we are in the majority, because one day we could be in the minority. And that's just self-interest in a way, but it's also, of course, a matter of sheer justice. One point about the situation in Europe and the situation in America that I think is worth bringing out first when we talk about religion and conscience is that, at least in American law, the word religion features on its own. Now, I don't suppose I need this audience really just to quote the First Amendment, but I just remind you that it is talking about the establishment of religion or prohibiting the free exercise thereof. It doesn't mention conscience, belief, or anything else. And of course, that immediately takes us into the big question about what is religion anyway. In contrast, following, I suppose, the United Nations Declaration, Article 9 of the European Convention for Human Rights says that everyone has the right to freedom of thought, conscience, and religion. So you've got conscience and religion both specified, so they're in a sense playing safe by mentioning both. And the second section refers to the freedom to manifest one's religions or belief. And the phrase, of course, religion or belief is a blanket phrase now, rather than just religion in many quarters. Now, that's all very well, but it immediately brings up the question, what do we say about religion vis-à-vis conscience? Are they going in parallel? Are they fighting each other? Or does one subsume the other? Now, there are some people who would say that conscience is just a subset of religious belief, but I don't think they're in the majority nowadays. Particularly amongst philosophers and other writers on the subject, I find a growing trend for people who want to say, actually, we don't need freedom of religion. Freedom of conscience does the whole work. And this, of course, particularly applies in societies, and I'm afraid we on both sides of the Atlantic tend to be living in such societies, where religion can be viewed with suspicion or even dismissed as irrational. I think sometimes, looking at it as a philosopher, this is a kind of hangover from the days of logical positivism, which I grew up with here in Oxford, where people would say that all religious statements are meaningless, only science sets the standard. Science decides what's not just true and false, but what's meaningful or meaningless. The philosophy of science has grown out of that long ago, in fact. But as so often, there's a bit of a time lag, and when I read the works of Richard Dawkins, I can see, for instance, the influence of logical positivism there only too clearly. Sometimes in a rather personal way, because he was a fellow of New College along with my old teacher, Professor A.J. Eyre, and that you can see the personal influence there, that evidence is only scientific evidence. And, I mean, in a recent demonstration in Washington, D.C., had a lot of placards about if it isn't science, it's fiction. And there is that attitude, and it's not just on the streets, it's in quite high-level publications. So some people want to dispense with the notion of freedom of religion. I mean, they look as well to freedom of association and other freedoms, but particularly to freedom of conscience. Just because religion is hard to define, they'd say, well, let's reduce it to freedom of conscience. Religion isn't special. There's nothing important about it. Why should it claim privileges? Is not the equality of all citizens, religious or not, important? And if I could just quote one writer on this, Brian Leiter, in his book Why Tolerate Religion, says that, in fact, there is no principled argument that picks out distinctive religious conscience as an object of special moral and legal solicitude. Similarly, Martha Nussbaum, a famous philosopher, in her book Liberty of Conscience, assimilates freedom of religion to respect for the faculty in human beings with which they search for life's ultimate meaning. Now, I mean, there is a truth in that, because I'm sure people who aren't religious do have quasi-religious views about the world and its meaning, and I would always myself, for instance, say that the denial of religion is part of what we mean by freedom of religion. But I don't think that freedom of religion should be reduced to freedom of conscience, and that's what I'm wanting to talk about. That freedom of religion is not a subset of freedom of conscience. It is itself something that's worthy of special protection. The European Convention on Human Rights seems to distinguish between belief and practice. You have, of course, an absolute right to belief, a limited right to practice in accordance with whether it clashes with other people's rights. And that can mean, of course, that other people's rights trump freedom of religion. Gay rights seem to be regularly in the courts trumping freedom of religion instead of being held in balance with them. I'm always been in favour of a reasonable accommodation, a balance, trying to give each side as much as you can of what they want. But too often I think the courts want to make a point about one kind of equality at the expense of freedom of religion. So one of the issues here is that sometimes people concentrate on religion as being merely religious belief. Leiter himself, whom I just quoted, says that beliefs or the attitudes of believers are central to the analysis of religion, precisely because it would be hard to see how mindless, habitual, or merely casual religious practices could claim whatever moral solicitude is due matters of conscience. So he's really belittling religion there. And he is one of those who think that religion delves in the irrational. It's dealing in things that aren't in any way susceptible to evidence or rational discussion. Faith has nothing to do with reason. As a philosopher, I've always insisted that faith is always faith in somebody or something, and therefore is also always susceptible to rational discussion, rational criticism, and that faith, therefore, is rational, at least at the level of being subject to rational scrutiny. Some faith may be misplaced, some may not be, but it isn't a magical ingredient within us. All I need is faith, and I've got faith, and it doesn't matter what you think, I got it. It isn't just about me, it's about what faith is in. And I think that's a very fundamental insight that I want to come back to. Leiter is contemptuous of religious belief on the grounds that, as he claims, as I've indicated, it's insulated from reason and evidence. That's shades, really, of Richard Dawkins again, that reason and evidence is what science says. One of the caps I wear is actually dealing with science and religion. It isn't, I find, a completely different topic from religion in public life and religious freedom, because we find that so many people in our society, particularly the thinking end of society, are really saying that science sets the standard for reason. Science is what common sense agrees with. Faith is something personal, very idiosyncratic, very odd. We can't do much about it, but it's not rational because science is what's rational. Now, I won't launch out into another theme, but I do think science itself depends on a metaphysical view of the world, a rational view of the world as being ordered, etc. So science without a rational underpinning is itself in trouble. And that's one of the things that logical positivism, I think, found very difficult. But nevertheless, science is an expression of human reason, but it is not to be equated with human reason. And once you realize that, to just dismiss religion because it isn't science doesn't get one very far. And to dismiss religion because it isn't science, and therefore say it's purely subjective, is something that, therefore, we should query and resist, at least insofar as just thrown out as an obiter dicta. And you find even judges tend to make these kinds of remarks, as if, well, of course, religion isn't something that's susceptible to kind of public rational debate, so we can't do anything about it anyway. All you can do is accept that some people have these funny attitudes to life, and in a free society we'll let them get on with it, but we can't discuss it rationally. It's not for public discourse. Well, the question I really want to confront here is how far can the assimilation of religion to conscience be made without loss to our understanding of religion? Why is the protection of either important? So as I've suggested, that just saying that religion isn't rational doesn't get us very far. Religion can learn from science. I don't want to separate the two, but I also think that science can learn from religion. At the moment, I'm serving on a committee in the Church of England advising the two archbishops on what they call their teaching document on marriage and sexuality. It's going to be a real hot potato in the church. And they call it a teaching document. I get more than a whiff of the idea that it's their idea of an encyclical. But nevertheless, it's all up for grabs at the moment, and I'm on the committee particularly advising them on science and social science. But I'm very aware then that the issue of science isn't apart from religion, because religion is dealing with the same worlds that science deals with. That it isn't that religion is in one compartment and science is in another. If science says something about the kind of people we are and the world we confront, religion has to take account of that. I would say the reverse is also true, that if religion is about claiming truth, science also has to take account of that. So we all face one world. we don't live in different worlds. We don't live in a scientific world or a religious world. There is one objective world, and we're all trying to make sense of it. Which is why we should respect those with different opinions. Just as in science, science flourishes when there are competing theories. Wider, we must be willing to learn from other people who may understand something that we don't. Just as we might hope to be able to teach something to them that they haven't thought of. We all oughtn't to be just locked up in our separate compartments. We're all human, sharing the same human nature, the same, I would say, God-given nature, and facing the same reality together. That is something, again, I will come back to. But we live in a pluralist society. We live in a society with considerable disagreement. And democracy is really a framework for managing that, for encouraging debate, for resolving disagreement, for respecting the dignity and autonomy of each individual. And so it ensures the dominance of one point of view to the exclusion of others by, in fact, destroying itself at the roots. So when you get a majority position squeezing out minority positions, we're in a very dangerous position. It's as if once one party wins an election, instead of respecting the other party as Her Majesty's loyal opposition, they exterminate them, which of course has not been unknown in the past. And that means, therefore, that you really have, in a functioning democracy, to nourish the dissenting view, to nourish the minority view, and to realize that all may have insights which may help, in the end, the common good. While democratic decisions have to be made, dissent has to be respected, and coercion of others against their deepest held moral views must be avoided. So coercion of others' conscience, just as their coercion of their religious views, is obviously something that should be regarded as extremely distasteful. While we all have to live together, we don't all have to behave in the same way or have exactly the same beliefs. And so, as I've said, democracy is a framework for resolving the disagreement, not for enforcing majority opinion, not for silencing those whose views we don't share. And in a parenthesis, I might say I get very concerned about the position in British and American universities at the moment, when so many people think that the way to treat distasteful views isn't to offer counter-argument, but to stop them putting forward their case in the first place. And that applies, of course, particularly to religious freedom, because very often religious views are being targeted, but it applies to all views. And that at the moment, universities seem to become places where there is remarkable uniformity of view. And that isn't my idea of university. It wasn't the kind of university I went to, anyway. As I said, I was taught by A.J. Ayer. He was the rip-roaring atheist, the leading atheist of his time. I, in a way, went into philosophy because I wanted to show why I thought he was wrong. But he enormously stimulated me and made me think about my own views. He taught me how to do philosophy. And I think that's the job of a university, not to be taught what's true, but to be taught how to think about what's true. Now, by definition, religion concerns what's most important in someone's life. Religious belief, therefore, I think, sets the standard for the respect of conscience. In a way, I think conscience lies in the shadow of religious belief, and if you do away with respect for religious belief, it's remarkable how quickly conscience is soon disregarded. And conscience itself is not mere preference. If reasonable accommodation is to be made for conscience, we have to know what is a matter of conscience. I mean, it's as crucial an issue as to what is a matter of religion. So what is the difference between someone who's unwilling to work on a Sunday, Saturday or Friday because of a desire to engage in public worship? And incidentally, I don't think that freedom of worship is freedom of religion. It's a very small part of it in a way. But that's a particular case. What's the difference between somebody who does that and a fan of Manchester United who wants time off to see the football team he fanatically follows? It may be that it's the most important thing in that person's life. does that mean that's a matter of conscience? Or is it just a matter of what we feel ourselves? I haven't got any sympathy for supporters of Manchester United. Indeed, I haven't got any sympathy for any supporters of any football team at all. I'm only interested in the Somerset County Cricket Club. But nevertheless, I can recognise that some people have those preferences. And it's subjectively important for them. But is what's subjectively important something that always has to be respected? Is it connected with basic judgments about the meaning of life and our place of humans in the world? You may have heard the old joke about the soccer manager who was accused of treating football as his religion, and he said, indeed not, it's much more important than that. But that illustrates the fact that, of course, religion is generally thought to be what's most important in people's life. It's only a joke because we think, something's going wrong in that statement. So conscience need not be religious, and the denial of religion, as I've said, can be conscientious. But once freedom of religion is discarded, freedom of conscience becomes less respected, and not least because it becomes hard without a link to metaphysics to separate out our basic beliefs about truth from mere preferences, desires, whims, tastes. Deep commitments become opaque. What is a deep commitment? Because they're by definition private, they become difficult to recognise and accommodate. So the more that freedom of religion becomes attenuated, and I would say attenuated, as freedom of conscience, it includes a lot more and so much, everybody's sincere commitments, in fact, that it includes so much that you can't include it all as something law has to take part in or accommodate. So it all becomes impossible to protect, particularly in a legal setting. And of course, against all this, there's always the danger in the old phrase that people become a law unto themselves. And the minute you allow accommodation and exceptions to laws, there's the question how far they go. Conscience opens the floodgates to everything. Religion, because it's regarded as special and circumvents conscience, limits the thing a bit. Particularly, of course, as I've said, if you include denial of religion as well. Conscience, by its very nature, seems intrinsically subjective. In fact, in some writings you see references to the importance of individual integrity, me being true to myself. Well, that just means that it is very subjective. It's what I am. I must be true to my identity. But that's all very well. Religion isn't just like that. It may include that. But religion typically makes claims about objective truth, as I indicated when I talked about faith in something. And belief and practice are deeply entwined in religion precisely because religious believers consider that they're under an obligation which comes from beyond. There is an objective obligation. Religion is saying something true about the human predicament, about what humans are, that we have an inherent dignity, for instance, how we ought to be treated, that humans matter, and they matter particularly because they matter to God. So the religious belief in human dignity and worth isn't a subjective attitude. Your dignity doesn't matter because I bother about it. It matters because it is objectively a fact about you. It's something about God's creation and his love for humans. And the difficulty of drawing a firm distinction between freedom of religion and that of conscience does partly follow when people take a very subjectivist view of religion and forget that, true or false, it's making claims about something beyond, something about the nature of the world, something about truth. Not all religions say the same thing and probably aren't all true, but nevertheless, they're making claims about something coming beyond. It isn't just what I feel, my attitude. It isn't, I don't like bananas, but that's a fact about me. But the fact that I worship God isn't just a fact about me. It's a fact about what I think I ought to be doing because of what I believe to be true. So, the difficulty of making a firm distinction between religion and conscience immediately comes if you mention too much that religion is purely subjective. It's a preference. The reduction of religion to conscience carries with it the implicit implication that religious claims about reality, in fact, don't matter and probably are false or not to be taken seriously. But they do matter because typically beliefs about what's true in the case of religion will transcend loyalty to the state. And that's a powerful reason for safeguarding religious freedom, because the state is always going to be jealous of people's allegiance to another power, another authority. In this country, I like to think that it does matter that on the Queen's crown there is a cross surmounting it, that actually, and the coronation service draws this out, that she and the authority devolved from her are subservient to a higher authority. But it's easy to lose that, and in a democracy you begin just to count heads and count preferences, and majorities then begin to matter, and what matters is just what people happen to feel at a particular time. The democratic state can assume too much authority. Cecilia Bord, in Liberalism's Religion, she's talking later, said that states, not churches, have the authority to define their own spheres of competence as well as those of other institutions. The state is the final legitimate arbiter of the boundary between the public and the private. The state can define what constitutes harmful behaviour. That's not a bad description of what more or less is happening very often nowadays, but it isn't, I think, something that gives much comfort to those who believe in religious freedom, because the state is setting itself up above the demands of religion. It doesn't accept that there is a legitimate area where the state should not tread. I don't want to dramatise that, but there does lie the path to totalitarianism, that you'll find that a state which doesn't respect freedom of religion, that doesn't respect the importance of freedom of religion and the obligations that religion brings, will very often not be respecting other freedoms too, that freedom is indivisible. Not long ago I was in Russia lecturing in St. Petersburg and talking to somebody in the Russian Orthodox Church, quite a high dignitary, and he was quite gleeful about the fact that, in fact, that they were outlawing the Methodists because they were being funded from the United States and South Korea. I rather weakly pointed out, well, actually it was founded in England, and in fact the beginnings of the Methodist movement were here in Oxford down the road. That didn't mean anything. And but I couldn't help but reflect, if an orthodox branch of Protestantism like Methodism is outlawed, that freedom as such was in jeopardy in Russia. And I think you can only look at what's happening there to see that it is, that the Russian Orthodox Church is perhaps cozying up too much to a government that doesn't care too much about people who disagree with it. The state, therefore, has to accept it's not supreme, and that many of its citizens should believe they're responsible to a higher authority. And it does help, I think, if the state institutionally recognises that. Perhaps that's one reason for an established church, but that's for another session. A state's refusal to accept that shows the importance of entrenching freedom of religion, not just freedom of conscience. And another issue about freedom of religion as opposed to freedom of conscience that I want to just stress, of course, is that religion, rather than conscience, has an institutional aspect. Some might want to reduce that too to freedom of association, but again, churches and other religious organisations become particular targets because, again, they set up an alternative standards of authority, and without protection in law, they're at the mercy who finds their witness inconvenient. So we need institutions as buffers between the individual and the state. One of the things that worries me at the moment is the fact that there's a progressive erosion of all institutions, not just churches, women's institutes, choirs, anything, trade unions, between the individual and the state. And when that happens, ultimately what's going to happen is that the state gets more authority because there's nothing else to act as a referee between the war of all against all. And churches and other religious bodies aren't the only institutions that are important, but they're crucial for passing on their faith to new generations and for teaching even a code for morality. At one point, the Chinese, I think, were recognizing that churches had their use in bolstering moral teaching, but they seem to be backtracking a bit now. But anyway, there is a collective as well as an individual aspect to religion. Why is religion important? Can I just say briefly, and this again is a subject for another lecture, that religion is deeply entwined with human nature. I directed a research project here in Oxford on the cognitive science of religion, whose conclusion was very much that religion is natural. It just doesn't mean it's true, but even Richard Dawkins would accept that's where we start off, that children naturally have religious impulses, find certain religious stories easy to understand, and so on. But religion is there in all societies at all times, in different shapes and sizes, but it's really part of what it is to be human, and curbing it is curbing human nature almost as much as if you're not giving people enough to eat or to drink. So once all is reduced to subjective preference in democratic debate, it's all too easy for the dissent of a minority to be swept aside by the majority in as ruthless a fashion as any totalitarian state. And then we end in a phrase that I rather liked because it latched onto something I've been talking about for years, the dictatorship of relativism. The majority gain power and determine what is true. Religion stands for a notion of truth that's absolutely apart from what people happen to believe at a given time. Thank you very much.
Thank you, Roger, for those wonderful comments. We didn't plan this. We didn't consult with each other about what we were going to talk about, and so it works out very well that much of what I'm going to say this morning dovetails rather nicely with what Professor Trigg has already said. Much of what I'm going to be sharing with you this morning was actually inspired by an encounter I had 14 years ago at Texas Tech University. I don't know if you've ever been to Texas Tech. It's in Lubbock, Texas. And if you've ever seen the landscape of Lubbock, my understanding is that people from the moon go there and say, what a wasteland. But when I was at Texas Tech, I gave a talk at the law school on some of the issues concerning science and religion in public education. And after I was done, one of the members of one of the science departments, one of the faculty members, raised his hand and he said, you know, all you've given us are religious arguments. And I paused for a moment and I said, wow, I'm relieved. I thought you were going to say they were bad arguments. And that was the beginning of thinking about how certain philosophers, legal scholars, and others think about the nature of religious beliefs. Roger already spoke about the work of Brian Leiter. There are others as well. And so this morning I want to focus on some of those writers and how they have understood religious belief, not just in terms of religious belief as being somehow sub-rational, but religious belief as something that could be understood under some other general category or some other fundamental right. It's a view that I call religion as comprehensive doctrine. It is a view often associated with thinkers such as Ronald Dworkin, John Rawls, Christopher Eisgruber, and Lawrence Sager. Each in their own way challenges the specialness of religion as a distinct category of legal protection, arguing that once we see what questions of human existence conventional religions are really trying to answer, we should conclude that religious liberty and freedom of conscience should protect not only beliefs and practices that we typically associate with conventional religions, but all beliefs and practices that arise from the foundational ultimate concerns that give all our lives meaning and purpose. Although I am somewhat sympathetic to this account, I want to raise a concern about it, namely that it may have the unintended consequence of teaching us the wrong lesson about conventional religious beliefs and practices, and ironically making it more difficult for courts and legal scholars to grasp what those beliefs and practices really mean to conventional religious believers. I will argue that a more traditional understanding of religious belief, which I call the two sovereigns approach, though not without its own difficulties, can provide a conceptual corrective to this problem. In his 1993 monograph, Life's Dominion, Dworkin offers a defense of the right to abortion and the right to assisted suicide by arguing that both rights are grounded in the same principle that grounds religious liberty, the right of conscience. Dworkin writes, quote, "A state has no business prescribing what people should think about the ultimate point and value of human life, about why life has intrinsic importance, and about how that value is respected or dishonored in different circumstances. Because we cherish dignity, we insist on freedom, and we place the right of conscience at its center so that a government that denies that right is totalitarian, no matter how free it leaves us in choices that matter less," unquote. Dworkin argues for an understanding of religion that incorporates both conventional religious beliefs as well as conventional non-religious beliefs, as long as each is answering the same questions of ultimate meaning and purpose. So, for example, on the issue of reproductive autonomy, whether or not abortion, contraception, etc., should be proscribed by law, Dworkin argues that the state ought to restrain its hand, since the answer to the question on which he believes the debate turns, what is the correct way for one to respect our shared belief in the intrinsic nature of human life or sanctity of human life, depends on what one believes about the ultimate meaning of and purpose of life itself, a question over which reasonable and equally informed citizens may disagree. For this reason, coercion of any sort on these matters is inconsistent with the state's obligation to treat its citizens with equal concern and respect. Other writers offer similar understandings of religious liberty and freedom of conscience. For example, Eisgruber and Sager argue that, quote, "At its core, religious liberty is about the toleration, the celebration of the divergent ways that members of our society come to understand the foundational coordinates of a well-formed life," unquote. Conventional religious belief is one of the divergent ways to do this, but so is becoming a disciple of Socrates, appropriating the lessons of Jesus absent the theology, trying to emulate Henry David Thoreau, following the categorical imperative, embracing John Stewart's utilitarianism, or taking to heart the counsel of Jordan Peterson. John Rawls referred to these divergent ways as reasonable, comprehensive doctrines, which can be, in his words, religious, philosophical, or moral. Categorical commitments that arise from such comprehensive doctrines may include devotion to family and nation, a conscientious unwillingness to engage in organized violence, a discerning soul inclined toward personal grace and forgiveness, and or a sense of duty to live a life of integrity and virtue. None of these commitments, claims the RCD advocate, requires a religious belief in God. There are, I believe, advantages to this approach, one of which is that it seems consistent with our egalitarian intuitions. That is, placing religious liberty under a more general category does not privilege conventional religious answers to the same questions that conventional non-religious answers may answer differently, or ironically in the same way. Take, for example, the U.S. Supreme Court's holding in Burwell v. Hobby Lobby. In that case, the court, under the Religious Freedom Restoration Act, allowed 3 closely held family-owned companies to be exempted from a regulation issued by the Secretary of Health and Human Services that required all businesses, with some exceptions, to provide access to 20 forms of birth control as part of their employees' medical insurance plan. The companies argue that because 4 of these methods may result in the death of early embryos, the regulation constituted a substantial burden on their religion under RFRA. Why was it a burden? Why was it a religious burden? According to the companies, their theological traditions hold that early embryos are full-fledged members of the human community, and for that reason the government forcing them to cooperate with the destruction of embryos violates the company's religious liberty. But let us imagine another closely held company we'll call Diversion Doorway. Hobby, diversion, lobby, doorway. If you weren't It took me about 45 minutes to find the right. So Diversion Doorway is owned by atheists. So like Hobby Lobby, Diversion Doorway objects to the HHS regulation, but on slightly different grounds. Suppose that instead of appealing to the theological beliefs of its owners, since they don't have any theological beliefs, it appeals to the owners' deeply held ethical beliefs that rely almost exclusively on a Thomistic, Aristotelian, hylomorphic account of substances and their natures. They're sort of secular Thomists. This is certainly possible. Mortimer Adler was actually a secular Thomist for quite some time before he converted to Christianity in his 90s. Are these religious or philosophical beliefs? In the abstract, it is not clear, since for many religious believers, their interpretations of their theological traditions rely heavily on such philosophical categories, whether they realize it or not. It is difficult, for example, to imagine an account of transubstantiation that does not rely on some metaphysical assumptions not directly derived from Scripture. But our atheist owners do not have to worry about reconciling faith and reason, since all they have is reason. This is why it is unlikely that they would receive an exemption under RFRA, for the statute is triggered only when a federal law, quote, substantially burdens a person's exercise of religion, and the owners of Diversion Doorway don't have a religion. Because the owners of Hobby Lobby and Diversion Doorway hold the exact same deeply held moral conviction that it is wrong to cooperate with the destruction of human embryos, no matter how immature, it seems unfair that the state would allow an exemption for the former, but not the latter, solely because one is the result of divine sanction, while the other is the result of philosophical reflection. So one can see why religion as comprehensive doctrine approach assuages our egalitarian worries. Of course, one may think that religious exemptions are a bad idea, period, right? But nevertheless argue that if the law allows for them, their allocation should not be conditioned on whether or not a recipient's deeply held beliefs or practices are conventionally religious. On the other hand, the religion as comprehensive doctrine approach, I think, has a glaring disadvantage. It seems to exclude from our vision factors that often make certain convictions and practices significant and weighty for religious believers that are missing from the convictions and practices of those who are not conventionally religious. Take, for example, the case of Samantha Aloof, a young American Muslim woman who was denied employment by Abercrombie and Fitch because she would not remove her religious headscarf if she were hired. The company has a policy that all its employees dress in a certain way that projects a certain look consistent with the image it wants the buying public to associate with its brand. According to Abercrombie, an employee wearing a traditional Muslim headscarf would not project that look. The U.S. Supreme Court, in an 8-1 decision, held that the company had violated Title VII of the 1964 Civil Rights Act, as amended, which states that employees cannot, quote, fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, unquote. Because the Act defines religion to include both beliefs and practices, and because it requires businesses to accommodate religious employees as long as the accommodation does not place undue hardship on the business, it does not matter to the government that the store's policy is neutral on its face and applies equally to all employees. Now, setting aside the question of whether it is wise to include such a religious accommodation in civil rights legislation, what stands out about this case vis-a-vis the religion as comprehensive doctrine approach is that there does not seem to be a secular or non-religious parallel to Miss Alouf's plight. She believes that she is commanded by divine sanction to wear the headscarf. To be sure, other employees may want to wear the exact same headscarf for a variety of other reasons, including impressing one's spouse, hiding a birthmark, personal modesty, wardrobe aesthetics, or expressing solidarity with one's persecuted Muslim neighbor. But none of these cases includes anything like a divine command. For Ms. Aloof, not wearing the headscarf constitutes disobedience to a sovereign she did not choose. It does not constitute the exercise of a personal choice in response to contingent, self-regarding, and communal circumstances, as it would in the other cases. So there's a sense in which religious liberty can be understood as a legal right that is grounded in an undeniable reality of human existence. Most religious citizens see themselves as under the authority of two sovereigns, an earthly government and a divine government. For this reason, as the argument goes, a nation's laws and policies should be crafted in such a way that conflicts between the two sovereigns in the lives of its citizens occur as infrequently as possible. As I've already noted, I call this the two sovereigns approach to religious liberty. This seems to be the view that was embraced by many of the American founders when they argued for the incorporating of this logic in several state constitutions. There was a famous debate concerning the taxation, a tax instituted in the state of Virginia that would pay Christian ministers, and Thomas Jefferson and James Madison became deeply involved with that. And one of the types of arguments that both of them offered was this sort of appeal to the fact that a citizen's conscience on this matter is tightly tethered to what they believe that they owe God. So Madison, for example, says, because we hold it for a fundamental and undeniable truth that religion, or the duty that we owe to our Creator, and the manner of discharging it can be directed only by reason and conviction, not by force or violence. The religion then of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise it as they may dictate. This right is in its nature an unalienable right," unquote. Often accompanying this two sovereigns approach is a call for government and the citizenry to exercise a kind of epistemic modesty on matters of religious conviction. Reasons, for example, that citizen A is convinced give her warrant to believe that X is a divine command that she ought to obey may not convince citizen B, who is no less rational and no less willing to obey a divine command, if he could be persuaded to believe that there really is one. Given the gravity of the question, is X a divine command, the citizen who employs the state to coerce his neighbor to practice what the neighbor finds no warrant to accept risks divine judgment for interfering with what the neighbor conscientiously believes or does not believe are his proper duties to God. And this was actually one of Madison's points. He writes in the Memorial and Remonstrance, quote, "Whilst we assert for ourselves a freedom to embrace, to profess, and to observe the religion which we believe to be of divine origin, we cannot deny an equal freedom to those whose minds have not yet yielded to the evidence which has convinced us. If this freedom be abused, it is an offense against God, not against man. To God, therefore, not to man, must an account of it be rendered," unquote. Not surprisingly, a similar call to epistemic modesty, minus the admonition to avoiding courting posthumous punishment, plays an important role in the cases made by the religion as comprehensive doctrine advocates, or the RCD advocates. Rawls, for example, writes that, quote, "When there is a plurality of reasonable doctrines, it is unreasonable, or worse, to want to use the sanction of state power to correct or to punish those who disagree with us," unquote. Taking a slightly different approach, Dworkin emphasizes the dignity of the individual citizen to make judgments for herself about ultimate matters pertaining to religion and personal ethics, even when others in the community may reasonably believe that those judgments to be mistaken. Eisgruber and Sager claim that, quote, "The core project of religious freedom is the project of finding fair terms of cooperation for ourselves as a religiously diverse people, but that no members of our political community should be disadvantaged in the pursuit of their important commitments and projects on account of the spiritual foundations of those commitments and projects," unquote. This implies that the state does not have the moral authority or competence to be able to distinguish between legitimate and illegitimate spiritual foundations. So the TS approach, or the two sovereigns approach, includes the epistemic modesty of the RCD approach without excluding from our vision the religious quality of certain beliefs and practices that do not seem to have any non-religious parallel. To illustrate what I mean, Consider a fictional case, the fictional case of Joel Goldberg, owner of Goldberg's Photography, whose employees consist of Goldberg, his wife, and 2 children, all of whom are Orthodox Jews. Located in Denver, Colorado, the business owner has never run afoul of any of his region's anti-discrimination laws, and he has earned a reputation of not turning away any customers because of their religion, race, gender, sexual orientation, or nationality. Imagine that Goldberg is approached by a local Christian minister. We'll call him Mr. Convert. So Mr. Convert asks Mr. Goldberg if he could take photographs at the church's upcoming biennial baptismal ceremony. The minister informs Goldberg that the church plans to post the photographs on its website as a way to publicly welcome the baptized into the community. Goldberg, however, is curious about the church. He says, "What's the name of your church?" Mr. Convert answers, "Rocky Mountain Jews for Jesus." He goes on to tell Goldberg that it is a Christian congregation consisting exclusively of converts from Judaism, including the 4 adults whose baptism is he's being asked to photograph. Goldberg then tells Mr. Convert, quote, "I am sorry, but I will not cooperate with the celebration of a liturgical event that I believe is apostasy," unquote. He goes on to explain to Mr. Convert that he would have no problem photographing the same 4 individuals near or in any body of water, including being playfully dunked by the Christian minister or a layman. But baptisms, he argues, because they are liturgical, are different, and most especially so when they involve the public renunciation by others of one's own faith. This activity, Goldberg emphatically tells Mr. Convert, is one in which I cannot participate. Not pleased with the news, Mr. Convert files a complaint with the Colorado Human Rights Commission, arguing that Goldberg's refusal constitutes unlawful discrimination based on religion. At trial, Goldberg insists that it is not Mr. Convert's religion that is the issue, but rather the activity for which Mr. Convert is asking Goldberg to employ his artistic gifts to assist in celebrating. This activity, argues Goldberg, has deep liturgical significance for both himself and Mr. Convert. For Mr. Convert, it is done in obedience to Christ. For Goldberg, it is a public act of apostasy and disobedience of the Torah. And yet, the Colorado Human Rights Commission rules against Goldberg, saying the following, quote, "The Supreme Court has recognized that in some cases conduct cannot be divorced from status. This is so when the conduct is so closely correlated with the status that it is engaged in exclusively or predominantly by persons who have that particular status. We conclude that the act of baptism constitutes such conduct because it is engaged in exclusively or predominantly by Christians. Therefore, Goldberg's distinction between not serving Christians and not cooperating with the celebration of a baptism is one without a difference. But for his religion, Mr. Convert would not have sought to baptize his congregants. But for his intent to do so, Goldberg would not have denied Mr. Convert his services." By ignoring the liturgical significance of baptism to both those who believe in it and those who don't, that is, by treating it as just another activity closely correlated with a citizen's protected status under the law, our fictional commission is not only not taking rights seriously, that's R-I-T-E-S, it is effectively redescribing a liturgical practice in terms alien to the citizens, both believers and non-believers, who indeed take that practice seriously. But under the RCD approach, it is not clear how a court could adequately account for the religious quality of baptism without privileging religion in some way, which, as we have seen, is verboten under the RCD approach. So perhaps the RCD advocate will just bite the bullet and argue that given some principle of equality, such as what Eisgruber and Sager call equal liberty, or Dworkin calls equal concern and respect, the state is obligated under its anti-discrimination laws to punish Goldberg for his refusal of service, even though the only way for him to avoid punishment, in the words of John Locke, is, quote, "to join in the worship and ceremonies of another church," unquote. But this seems to be the Platonic ideal of a violation of religious liberty that writers like Locke, John Milton, Roger Williams, Madison, and Jefferson had in mind. I should note at this point that the imagined holding of the Colorado Human Rights Commission that I had just read to you 3 minutes ago is taken nearly word for word with minor adjustments to fit the fictional case from the very real Colorado Court of Appeals ruling in the Masterpiece Cake case, currently pending on appeal in the United States Supreme Court. In that case, a baker, Jack C. Phillips, owner of Masterpiece, refused to make a custom wedding cake for a same-sex couple, Charlie Craig and David Mullins, who had planned to use the cake in a reception celebrating their wedding with family and friends in Colorado after the couple had received their nuptials in Massachusetts. As in the fictional baptism case, the Colorado court rejected the defendant's argument that his refusal of service was not based on the status of the customers, but rather on the nature of the ceremony that he was asked to employ his talents to help celebrate. It seems to me that this ruling does indeed make sense, but only if one redescribes weddings in a way that eliminates the religious dimension that is integral to the observant citizen's worldview. For someone like Jack Phillips, a devout Christian, weddings, even when they are conducted under the auspices of institutions, either governmental or religious, that are outside of his own faith tradition, have liturgical significance. When he reads Scripture, for example, he is told that Christ's relationship to the church is analogous to the relationship between husband and wife in marriage, that adultery is prohibited by the Ten Commandments, that marriages that occur prior to the conversion of at least one of the partners are ecclesiastically binding afterwards and may be a means of grace, and so forth. If he were to read the Catechism of the Catholic Church, he would find that the Church teaches that marriage, understood as a voluntary, permanent, conjugal, and exclusive union between one man and one woman, has a special place in the created order that cannot be fully grasped by natural reason. If he were to examine the histories of his faith as well as other religions, he would discover how many of them have developed over the centuries sophisticated and complex rules by which to determine whether a marriage entered into by any of its followers under civil law or the authority of another religious group counts as a real marriage in the eyes of God. Thus, for religious believers like Phillips, weddings are more like baptisms, bar mitzvahs, and burials than they are like birthday parties, baby showers, or barbecues. This type of analysis is relatively easy to formulate if one makes an effort to understand how most religious believers see their own faith. They typically do not see it as just another exercise of individual autonomy consonant with their own vision of the good life, but as a discrete category of living that places them under the authority of a sovereign that may at times demand obedience contrary to the mandates of their culture. This is precisely how the U.S. Supreme Court interpreted Miss Alouf's headscarf. They accepted the way she sees her headscarf and not simply as Abercrombie and Fitch or a philosophical materialist sees her headscarf. The RCD approach, despite its many important insights, makes such an analysis nearly impossible. For as we have seen, it was constructed to be an eliminative theory. That is, one of its essential features is to eliminate, or at least greatly diminish from our vision, those aspects of religious belief and practice that most conventional religious believers would consider essential to their faith, which by their very nature contravenes John Rawls's requirement that free citizens, quote, regard themselves as self-originating sources of valid claims, unquote. In that sense, ironically, the RCD approach betrays its call to epistemic modesty, for it requires imposing on conventional religious believers an understanding of religion over which reasonable people disagree. Thank you.
Thank you, Frank and Roger, very much indeed. We've got about 30 minutes for questions. Who would like to go first? Yes.
Thanks very much. Cecilia Bolt from the University of Oxford. Thanks a lot. I think there were two great papers and very complimentary too. So I took it that you both are engaged in a similar project, which is to criticize and reject the kind of liberal, neutralist attempt to reduce religion to conscience or to what Rawlsians call conceptions of the good. And we're both trying to explain the sense in which we should keep the sense that religion is special. So I just have two thoughts about both your formulations, because even though they have one in common, they're also quite different. So in the case of Professor Trigg, so what's special about religion is that it's about the search for truth. So it can't be just conflated with any preference or hobby, such as a sporting preference. So one interesting implication of this is that anti-religious atheist convictions, which make statements about the truth, also count as religious on your account. And of course, there are people who are ready to bite that bullet. So I think Doug Laycock in the US says, anti-religion, a critique of religion counts as protected under freedom of religion. I was wondering if you were ready to bite that bullet and you'd offer the same protection to atheists as you would to religious citizens traditionally understood.
Shall I answer that first? Yes, I think actually I did say as an aside that I thought that freedom of religion did include the freedom to deny religion. So I do think that atheism, I mean, if you take that stand, you're obviously, I mean, one way of putting it, but perhaps this is giving preference to religion, is to say that it's in the shadow of religion, but it is actually dealing with that kind of issue, and that must be protected. I mean, in a free society, if people are free to profess a religion, they're free to deny it too. They're free to argue about it. So that's essential, I would have thought.
And they would apply to accommodation and exemptions, not only to negative freedom.
Yes, but up to a point. I mean, when I say up to a point, of course, the difficulty is embedding them in a story which shows how it's related to their fundamental beliefs. But a humanist who has very definite views about human nature ought, I think, to be protected in that way. But the trouble is you get the attenuation of it, and the problem is where to draw the line, as indeed to some extent with religion, because some things are going to be less important, obviously.
Can I ask the floor to Professor Beckwith? Or I had a question about the second paper, so very quickly, if I may. So I just think that your explanation of why religion is special is very different from Professor Trigg. So what's special about religion is that it has to do with divine command, right? What you call the two sovereigns. So it's the fact that something is demanded by God that makes it special. So of course, wearing a headscarf is not a fashion statement. It has to be taken seriously as something that one does as a matter of religious integrity. But if that's the case, if that's what defines why religion is special, then lots of secular beliefs will have exactly that feature, right? They will have the kind of categoricity that we associate with religion. So secular pacifists are the paradigm of this.
Yeah, one of the things that I want to make a couple of distinctions here. One, what I was trying to do in the paper was to show that there is something about religious traditions that there isn't a secular parallel. That's certainly correct. But I'm not denying that we shouldn't, in our laws, in some cases, include conscience protection for people that don't hold religious beliefs on matters of great controversy. So, for example, one of the reasons why I use the diversion doorway Hobby Lobby illustration is to point out that on that issue, what is the nature of embryos? Are embryos human persons, or are they just simply human beings that haven't acquired a characteristic that is worthy of protection? I don't think a person has to be a religious believer to hold an informed position on that. In fact, I have several friends who are not religious believers who are very skeptical about things like embryonic stem cell research for precisely those reasons. So I don't think you can come up with a way to deal with that in the wholesale. You almost have to deal with in the retail. That when on certain sorts of questions, and they are usually the questions involving sex and death, right? That's where, if you look at the issues over which people are deeply divided, and on those questions, it's very clear that both religious believers and non-believers have, or non-religious individuals hold deeply held beliefs. But I don't want to say that by incorporating or creating legislation that is able to carve out exemptions for everybody, that is the same as religious liberty. So that's the distinction I want to make.
Thank you both. Hello? Can you hear this? Yeah. Ryan Day, AGF International. I'm interested in maybe your thoughts on the anthropology that underpins a lot of what's been touched upon both today and yesterday evening. And the hollowing out that some might argue conscience has had maybe in the general view in the West, whether it be jurists, whether it be your average person. As I understand it, and again, correct me if I'm wrong, the post-48 tradition in human rights was very much assuming that there was an inherent value to the individual that has to be protected and recognised, and that was bound up in a certain nature. In particular, the kind of thing that makes being human special, that allows for conscience to be practised. So the state can't dominate the individual post-48. I'm interested as to how far you think there's been a cultural shift in what we believe conscience to be, and how significant that is, and is there a particular anthropology that you think best protects religious freedom?
I wonder if the shift isn't just in anthropology, but in epistemology, that I think there's a much greater emphasis on the subjectivity of ethical belief, and people have lost a grip sometimes on the notion that moral beliefs are claiming truth about the human condition. In moral philosophy, a lot has been made of the fact-value distinction. Facts are what science says, values are what people just individually think. So we all agree about the facts, and we all have different values. And you notice how people talk about values nowadays. Politicians are always talking about values, British values. And there is a nasty subjective connotation to that, really, which is why the notion of British values doesn't sound very clear, because it's something we all have in common, but it's all subjective, so we don't have it in common. If you're talking about truth, about recognition of dignity, for instance, or the value of human freedom, you're starting in a different place from if you're talking about me and my attitudes, my preferences. Now, in a democracy, it's very easy, in a kind of public opinion style, just to count preferences and count heads without going into whose preferences are right or justifiable. And I think that's the coward's way out, actually.
I think you find in much of contemporary political thought, and here I'm going to talk about Rawls in particular, an attempt to ground those originally religious intuitions in a sort of secular creation narrative. So you have human beings behind the original position, or in the original position behind the veil of ignorance. So you have human beings untainted by original sin, right, behind the veil of ignorance, that is having a God's eye point of view. So I think you find in the West, at least, I don't think you get this political liberalism, these appeals to equality and dignity and so forth, without the original views that, as you mentioned, come out of the post-World War II declarations on human rights, which I think were clearly informed by a kind of Christian, Judeo-Christian way of looking at human beings. So, and for that reason, I mean, they're clearly attractive. We want to support them. But if you've given up, if you've abandoned, let's say, the idea that those beliefs are ultimately rational or defensible, well, how do you defend them? Well, you have to defend them somehow, and I think you find many philosophers doing so in very creative ways, but it's interesting how the attempt is in some ways kind of a parallel sort of creation narrative.
I have a question for Professor Beckwith. I'm Brian Kelly. I'm a PhD student in political science from the University of Colorado.
I was just there.
Oh, really?
I spent a year there as a visiting professor.
Oh, okay. In Boulder?
Yes, it's lovely. Doesn't get hot like Central Texas.
No. Yeah, so my question was, in your talk you spoke a lot about conventional and orthodox and religious traditions, and talking about people coming from that position. And so my question was, what are the sort of outer bounds of that for unconventional religious belief or unorthodox or like beliefs attributed to new religious movements, or if there's a necessity for some form of orthodox religious belief with an expanded community to buy into in order for it to have that sort of legal recourse.
When I use the phrase conventional religious belief, I'm talking about sort of what we would see as any belief system that has within it a kind of appeal to a transcendent source of authority, and for that, or a transcendent source of meaning and purpose, that one, in order to, let's say, live in a religiously authentic way, has to live consistently or in accordance with that transcendent source. That's broad enough to include even religious points of view that are not technically monotheistic. So we think of, for example, certain forms of Buddhism and Hinduism that are not monotheistic in the sort of Western sense, but you still have a kind of enchanted worldview that has authoritative literature. So when I use the phrase conventional religious belief, I'm including those groups as well. And obviously, I'm also including new religious groups. So, for example, I wouldn't say, if I were, let's say, a really strict originalist concerning the U.S. Constitution, I wouldn't say, well, the First Amendment doesn't apply to Mormons because they began in 1830. That would be, so for me, it's a much higher level of principle.
Hi, Ian Lee from Durham University. I'm an academic, a lawyer, I'm currently engaged in a 3-year study on freedom of conscience. I was interested that you both drew a distinction between freedom of religion and conscience, drawn partly on the basis of duty, or obligation to deity. And I certainly agree it's important to recapture that perspective as against autonomy-based accounts. But like Cecile Laborde, I'm troubled by where this leaves non-religious conscientious objectors. And like her, the case of the non-religious pacifist sprang to my mind as well. A person who has a moral belief that it's wrong for them to take life, but it's not religiously derived. And it's important to focus on such a person, I think, in part because, not under the First Amendment, but certainly under the International Human Rights Statements, Article 18 of the Covenant, Article 9 of the European Convention on Human Rights, these are the right of freedom of conscience is protected distinctly. And then, of course, there's a qualified right to manifest one's religion or belief. So where does that leave conscience in this distinction?
Yes, but I wanted to resist the idea that freedom of religion can be reduced to freedom of conscience, but that doesn't mean that we forget freedom of conscience as itself important. In fact, my argument would be that actually if you genuinely respect freedom of religion, we're more likely to be sympathetic to the freedom of a non-religious conscience. The non-religious pacifist, for instance, surely is more respected because we also respect the religious pacifists, that we see that they're coming from, in a sense, not exactly the same position, but they're getting to the same conclusion. I find that if you distrust freedom of religion, then freedom of conscience itself becomes very much more problematic. It isn't rooted in something that people recognize, and the question is, it just becomes one preference, and why should one person's preference count more than another? If you root freedom of religion, then non-religious similar consciences are obviously to be protected. But without religion setting a standard, conscience is just set adrift, and any subjective commitment just seems to be possible as a conscience. And you begin to lose grip on the notion, I think.
I think a good illustration of what Roger is saying can be found in 2 U.S. Supreme Court decisions, one called Seeger and the other Welsh. They were cases involving conscientious objectors that wanted to receive that exemption under a statute, federal statute that defined
religion a specific way, that is, having a sort of commitment to a supreme being. And what the Supreme Court said was that in the individuals in these cases, their commitment sort of took the place of God. And so, in a sense, and I don't know if this is what Roger is saying, is that once you have the sort of the paradigm case, it's much easier to sort of extend the idea of conscience to those that are not conventionally religious. In other words, it works better that way. I don't know if that's what you're saying, but I think those two cases are really, I think, helpful in sort of seeing how one can make that case to extend the conscience from religious believers to those that don't hold religious beliefs.
Professor Anderson.
Julian Rivers, University of Bristol. I had a question for you, Roger. If I understood you rightly, you suggested there was a problem with the state's claim to sovereignty. And I wasn't clear what you thought the problem was or what you thought the alternative was. So I suppose one might be a philosophical anarchist and deny the legitimacy of any form of government. Or you might be a neo-medieval pluralist and think that somehow our law can emerge from a contest of perpetually competing authority claims, sovereignty claims. And I think that's a genuine option. So if one thinks of the work of Neil McCormick, suggesting that that's how we should understand the relationship between the member states of the EU and the EU itself as a perpetually contested system, ongoing dynamic system of competing sovereignties, and the law somehow is generated by that sort of a space. But I'm left with, I suppose, the standard modernist assumption that the buck has to stop somewhere, that the system has to have a point of finality. And that's what the claim to sovereignty is. It's the claim that what one has decided is to be, for all practical purposes, the answer, because there is no other higher instance to which one could appeal. And then the question becomes one of content. We're back to what rights, what laws. So why is the claim to sovereignty itself problematic from your point of view?
Well, because it's the same claim that a totalitarian state would make, that it has ultimate control over all parts of human life, that in fact it can't and shouldn't respect. There are certain elements of human life which should not be under state control. I don't think in this country we believe that the Queen is sovereign full stop, because the coronation ceremony surely says that she is under a higher authority, and I think that's part of the doctrine.
Very briefly, can I come up? Are you not confusing the extent of jurisdiction with sovereignty, as in the right to take a final decision, ultimate decision? You've talked about sovereignty in the sense of being able to rule on every single matter, to have universal competence or omnicompetence. But that's not the same thing as political supremacy, I don't think.
But supremacy suggests that you are the ultimate authority. And certainly in this country, it's always been thought that the monarch is under a higher authority and therefore must respect that higher authority and respect people's conscience in response to that higher authority. Therefore, there is a whole area of human life that the state should not think of controlling. And now, going back to what was referred to earlier as the myth of Magna Carta, I do think that Article 1 of Magna Carta does begin to point to that in carving out the discipline of the church apart from the discipline and the sovereignty and the law of the state, it is suggesting that there is a realm that the state should not be controlling. And it isn't just because the church is a powerful institution. I mean, that shouldn't be the doctrine. It's because the church itself is pointing to the sovereignty of God. And we do talk about the sovereignty of God. So, I mean, there is a question about the sovereignty of the state versus the sovereignty of God. It depends what you mean by sovereignty. But the idea that the state is not the ultimate authority, that therefore there are times when I should even be willing to disobey the law. I mean, the Americans amongst us would recognize that the Americans did realize there was a point at which they thought they should disobey the law. Well, right or wrong in that instance, nevertheless, there is a always a question that we are answerable to principles and standards that are not defined by the state, and particularly in a democratic state, should not be defined by the majority. They're answerable to something beyond. Now, how you capture that, and whether the word sovereignty is the right word, is a matter we can talk about, but I certainly don't think the state is where the buck stops.
Jonathan Chen, visiting fellow of Bond Center. I have comment on Professor Trigg's view on conscience. According to Professor Trigg's view, conscience is something personal, subjective. I think this one view on conscience, for example, according to the Confucian tradition, conscience is something governed by the principle of heaven. And the principle of heaven is something objective. We can be mistaken about the principle, but we can discover that principle as well. So I don't know why you think that conscience is something subjective. Maybe it is because you hold the view that there is a sharp distinction between fact and value. I don't know whether that is the ground that you hold for the view that conscience is something subjective. If that is the case, then I have a question about what do you mean by fact? For me, fact is something represented by a true statement. So the question is whether ethical statements or moral statements can be true or not. And if you argue that ethical statements cannot be true, then I think you have trouble to give us a whole bunch of arguments for that. And my second comment on your distinction between, or your view on the relationship between science and religion. Do you think that both about reality, right? But I think there is an important difference between science and religion. I think science is something that can be confirmed. It is confirmable by human observation. But I think most of the claims of religious statements cannot be confirmed by human observation. I think that is the major difference between the two things. I agree that religious statements are not nonsense. I do not agree with AJA. But I do think that religious statements are not confirmable. And that makes a sharp distinction between science and religion, or reason and faith.
Well, you've raised a lot of most important points there, and we won't get any lunch if I really answer them. But certainly on the question of, well, let's start with your first one about conscience. I mean, when I was talking about conscience being subjective, I was more talking about how it is viewed by people nowadays than my own beliefs. I do believe that people's conscience is responsive to a moral truth. And it should be, and that's why I would say that moral conscience should be respected, even if it isn't religious. I do believe there is a truth, but even in morality, that moral statements are true or false. And that therefore it's most important. But that isn't how a lot of people regard conscience. For many people, even the kind of people who are trying to reduce religion to conscience, they're thinking of conscience as not being about some kind of moral realm which, to pick up what you're saying, isn't confirmable by science. They're just saying, let's take the subjective attitude. On the question of, I suppose, science and religion as well, and that takes us into a big debate, but I don't think it's as simple nowadays as you say, to say that science deals with what's confirmable. Unfortunately, much of the frontiers of science is dealing with things that are far from confirmable. You just think how physicists are talking about an infinite number of universes none of which can be confirmed. Now, physicists will quite seriously talk about that. I think it's metaphysics, not physics. But nevertheless, there are lots of things that can't be confirmable, or when you're in the realm of subatomic particles. They're only very, very indirectly confirmable. So I mean, physics itself doesn't lend itself to that kind of simple observation nowadays, I think.
But when I say science is confirmable, I'm not saying individual hypothesis, scientific hypothesis.
Thank you very much, John. Maybe we can carry on the conversation because clearly that will occupy lunch. And we've just hit 1 o'clock. Thank you to all of you for some fantastic questions, and thank you especially to our two speakers. Can we give them a round of applause?